Good evening, everybody. May I please request our President, Mr. Vivekananda S., to escort Honorable Justice Shri S.R. Krishna Kumar, Judge, High Court of Karnataka, Bengaluru, upon the dais. May I also request our Secretary, Mr. M. Jagdish, to kindly escort Honorable Justice Dinesh Kumar, Judge, High Court of Karnataka, Bangalore, upon the dais. We would like to start by saying that through sharing knowledge and wisdom, one attains a sense of immortality by being alive in thoughts and memories. The LAHARI Advocates Forum extends a warm welcome to one and all present here to another one of the series of P.G.C. Changappa Memorial Lecture. This being the 17th one, we are having lecture on subject of evolution of LGBTQIA plus rights in this sanctified hall, a temple of knowledge and legacy of great minds.
Mr. R.A. Torrey says that, and we quote, "Prayer is the key that unlocks all the storehouse of God's infinite grace and power. Thus, in order to awaken our consciousness, to absorb the light of knowledge and wisdom which shall be bestowed upon us, we request Mr. Pampapati Gaddi, an established advocate, to call upon the grace through invocation prayers." Please give a round of applause to Mr. Pampapati Gaddi.
ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ, ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ, ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ, ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ, ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ. ತಾಯಿ ತಂದೆಯ ಬಿಟ್ಟು ತಪವ ಮಾಡಲು ಬಹುದು, ತಾಯಿ ತಂದೆಯ ಬಿಟ್ಟು ತಪವ ಮಾಡಲು ಬಹುದು, ದಾಯಾದಿ ಬಂಧುಗಳ ಬಿಡಲು ಬಹುದು, ದಾಯಾದಿ ಬಂಧುಗಳ ಬಿಡಲು ಬಹುದು. ರಾಯತ ಮುನಿದರೆ ರಾಜವನಿ ಬಿಡಬಹುದು, ರಾಯತ ಮುನಿದರೆ ರಾಜವನಿ ಬಿಡಬಹುದು. ಕಾಯಜ ಪಿತ ನಿನ್ನ ಅಡಿಯ ಬಿಡಲಾಗದು, ಬಿಡಲಾಗದು, ಬಿಡಲಾಗದು. ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ, ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಒಡಲು ಹಸಿಯಲು ಅನ್ನ ಇಲ್ಲದಲೇ ಇರಬಹುದು ಪಡೆದ ಕ್ಷೇತ್ರವ ಬಿಟ್ಟು ಹೊರಡಬಹುದು ಮಡದಿ ಮಕ್ಕಳ ಕಡೆಗೆ ತೊಲಗಿಸಿಯೇ ಬಿಡಬಹುದು ಕಡಲೊಡೆಯ ನಿನ್ನಡಿಯ ಬಿಡಲಾಗದು 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 ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಪ್ರಾಣವನು ಪರರು ಬೇಡಿದರೆ ಎತ್ತಿ ಕೊಡಬಹುದು ಮಾನದಲ್ಲಿ ಮನವ ತಗ್ಗಿಸಲುಬಹುದು ಪ್ರಾಣವನು ಪರರು ಬೇಡಿದರೆ ಎತ್ತಿ ಕೊಡಬಹುದು ಮಾನದಲ್ಲಿ ಮನವ ತಗ್ಗಿಸಲುಬಹುದು ಪ್ರಾಣನಾಯಕನಾದ ಆದಿಕೇಶವರಾಯ ಜಾಣ ಶ್ರೀಕೃಷ್ಣ ನಿನ್ನಡಿಯ ಬಿಡಲಾಗದು 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 ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಬರಿದೆ ಮಾತೆ ಕಿನ್ನು ಅರಿತು ಪೇಳುವೆನಯ್ಯ ತೊರೆದು ಜೀವಿಸಬಹುದೇ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಹರಿ ನಿನ್ನ ಚರಣಗಳ ಧನ್ಯವಾದಗಳು.
Thank you, sir, for gracing us with such melody and illuminating the atmosphere with positivity. Great mind says that if your action inspire others to dream more, learn more, do more, and become more, then you are a leader. With this, now we call upon our dynamic president of LAHARI Advocates Forum, Shri S. Vivekananda, to offer welcome address, welcome note.
Respected Honorable Mr. Justice P.S. Dinesh Kumar, Judge, High Court of Karnataka. Respected Honorable Mr. Justice S.R. Krishna Kumar, Judge, Honorable High Court of Karnataka. Justice C.M. Punacha, Judge, High Court of Karnataka. Justice Arvind, Judge, High Court of Karnataka. Respected members of the District Judiciary, respected Registrar General, Registrar Judicial, the Registrars of the High Court of Karnataka, Director and Deputy Director of the Karnataka Judicial Academy, Mr. Shashi Kiran Shetty, Advocate General for the State of Karnataka, Additional Government Advocates and Pleaders, Mr. Arvind Kamath, ASG for the High Court of Karnataka, Mr. Shanti Bhushan, ASG for the High Court of Karnataka, State Public Prosecutors, Mr. Vishal Raghu, Chairman of the Karnataka State Bar Council, Sri Vivek Subbareddy, President of the Advocates Association, Bengaluru, Mr. T.G. Ravi, General Secretary, Advocates Association, Bengaluru, Sri Harisha M.T., Treasurer, Advocates Association, Bengaluru, members of the Governing Council of all the units, Sri B.V. Acharya, President of the International Commission of Jurists, office bearers and members of the International Sri L. Jagdish, President, Bangalore Advocates Literary Union, Sri M.M. Prashant, Secretary of the Bangalore Advocates Literary Union, Sri Chennappa Gowda, President of the Bangalore Advocates Cooperative Society, Sri Sonne Gowda, President Nyayamitra Sahakari Niyamita, respected senior counsels, principals and lecturers of law colleges, family and friends of late Sri P.G.C. Changappa, Sri K. Suryanarayan Rao, founder person of the LAHARI movement, Sri Uday Holla, director of the LAHARI Law Academy, brothers and sisters in the legal fraternity, dear invitees and friends. It gives me immense pleasure to welcome each one of you to the 17th P.G.C. Changappa Memorial Lecture. Sri P.G.C. Changappa was the first president of the LAHARI Advocates Forum. Sri Pulyanda Ganpati Caesar Chengappa was popularly known as Caesar or P.G.C. He was a person who was touched and moved by the youngsters in the profession, and he catered, he wanted to ensure that there is an organization that is set up for the growth and development of the advocates in general and the young advocates in particular. With this lofty ideal in mind, Mr. P.G.C. Changappa, along with the other senior members of the bar, started a study circle which later on became popular as LAHARI Advocates Forum, and which was started more than 33 years ago. The organization has grown many-fold and has branched out into various other organizations catering to various other requirements. We have the LAHARI Law Academy, which is a trust that caters to the professional development of young advocates and students. The LAHARI Law Academy conducts model parliaments, moot court competitions, quiz programs, and various other talent search activities. The LAHARI Advocates Forum conducts activities relating to the legal education. In fact, I must say, every Thursday, we have a study circle in the City Civil Court, Bengaluru, under the banner of Chintana Mantana, where legal issues, substantive law, procedural law, and various other aspects relating to law are discussed. Apart from this, I must also say the LAHARI Advocates Forum conducts blood donation camps, eye donation camps, and various other activities. The LAHARI movement also has a LAHARI book bank which encourages the advocates to read books, biographies, and autobiographies of legal luminaries. In fact, I must say, we unfortunately lost Mr. P.G.C. Changappa to an accident in 2007. As a mark of tribute to Mr. P.G.C. Changappa, the organization decided to hold the memorial lecture every year. In 2007 November, we had Mr. R.N. Narsimurthy address on Article 356 of the Constitution. Honorable Mr. Justice N. Santosh Hegde delivered the second lecture on Lokayukta, powers, prerogatives, and restrictions. Honorable Mr. Justice Shivraj Patil delivered the third lecture on human rights, rule of law, and role of advocates. The fourth lecture was delivered by Honorable Mr. Justice S. Rajendra Babu on Supreme Court and democracy. The fifth lecture was delivered by Justice R.V. Ravindran on corruption, certain dimensions. The sixth lecture was delivered by Mr. S.S. Naganan, Senior Counsel, on the topic Independence of Judiciary. The seventh lecture was delivered by Mr. Uday Holla, Senior Advocate and former Advocate General, on the topic Judicial Activism in Election Laws. Honorable Mr. Justice N. Kumar delivered the eighth lecture in 2014 on the role of judiciary in ensuring transparency in governance. The ninth lecture was delivered by Mr. B.V. Acharya, Senior Advocate and former Advocate General, on judgment in NJAC case. Honorable Mr. Justice L. Nageshwar Rao, Judge, Supreme Court of India, delivered the 10th lecture on decoding Uniform Civil Code. Honorable Mr. Justice V. Gopal Gowda delivered the 11th lecture on eminent domain, analysis of land acquisition law. Honorable Mr. Justice Mohan M. Chantangaudar delivered the 12th lecture on dimensions and paradigms of victim compensation in criminal trials. Honorable Mr. Justice S. Abdul Nazir delivered the 13th lecture on judicial intervention and legislative action. Honorable Mr. Justice A.S. Bopanna delivered the 14th lecture on nuances of joint custody and shared parenting. The 15th lecture was delivered by Justice Dinesh Maheshwari on shifting paradigms in implementation of court orders. We had Mr. Prabhuling Navadgi, Senior Advocate and former Advocate General, on Constitution of India, a transformative document. We have the 17th lecture being delivered by Justice S.R. Krishna Kumar on the evolution of LGBTQ plus rights. It is indeed a privilege again to invite each one of you to the 17th P.G.C. Memorial Lecture. Thank you.
Thank you, sir, Sri Vivekananda S., President LAHARI Advocates Forum, for such a warm welcome. Now we request Mr. Chandrasekhar Chanaspur, EC member LAHARI Advocates Forum, to present a bouquet to Honorable Justice Dinesh Kumar, Judge, High Court of Karnataka, as a token of our gratitude. Welcome, sir. We also request Mr. Rajendra Singh Chauhan to present a bouquet to Honorable Justice Krishna Kumar, Judge, High Court of Karnataka, as a token of our gratitude. We now request Mr. Girish Kodagi to present a bouquet to express our love and affection and thanks for her unrelenting and constant support to LAHARI Advocates Forum, to Srimati Shushila P. Changappa. Welcome, ma'am. And And we also request Mr. Girish Kodage to present a bouquet to express our love to Sri Surya Narayanu sir, founding member, LAHARI Advocates Forum. We welcome you, sir. We warmly welcome you, sir.
Thank you, Sri Chandrasekhar Chanaspur, Mr. Rajendra Singh Chauhan, Mr. Girish Kodagi. Now let us learn briefly about Mr. late Puliyanda Ganapati Caesar Chengappa, who is alive in our hearts and grateful minds for his vision, for sharing knowledge, wisdom, and for truly believing in our fraternity, for who strongly believed that young mind could become great success with great right guidance and paving way for such. Now we request Senior Counsel and Director of LAHARI at Law Academy, Sri Uday Holla sir, to share his thoughts and memories of late Sri P.G.C. Changappa.
Well, honorable judges, ladies and gentlemen, 50 years back, I came to the bar, young mind, just out of the college. You're always curious to find out who's around you. And I found one person, prim and trim, ramrod straight, running around like an Englishman, always in a suit. I inquired because, and apart from all that, his submissions before court were not very precise, to the point. So I inquired with people, who is this gentleman? I must go and speak to him. And he was none other than Sri P.G.C. Changappa. He has been a great soul. He was He came to the bar 10 years earlier to me in 1962. In fact, he enrolled himself in November 25th of September 1962. And he was the district pleader for nearly about 7 years. Thereafter, he became the government advocate in the High Court. He was in the panel of many institutions, companies. He was a very active member of the Bar Association. In fact, he was a secretary of the Bar Association. In 1973, he got one of the greatest lawyers that India had, Sri Nani Palkiwala, and there were 10,000 people to hear him. I don't think any other law academy or law function has had that many people. That shows the enormous capacity that Sri Chengappa had. He has been the treasurer, vice president of the Bar Association. Apart from all that, he was always carrying one small button, lion. He was a very active member of the Lions Club. And as I said, with his, the moment his black coat is over, he'll have his regular suit and he'll have his lapel, lion member. He was one of the finest of human beings that I have seen. Very courteous to the bar, courteous to the opponent, and courteous to the clients also, because I have seen him, how he interacted with people. A noble soul. He was the president of LAHARI. He was responsible amongst, of course, Mr. Suryanarayan Rao is there. He was the founder member and the brain behind LAHARI. All these people built up this LAHARI Academy, which has had so many eminent people coming and lecturing to younger members of the bar to ignite their thought process. And Chengappa was one of those founders. He was the president. He ensured that the LAHARI Academy and the LAHARI Forum grew. And thanks to him, today we have this function where we have a very eminent judge lecturing on LGBT, which is a very hot topic for all of us. Recently, there are people who are saying that there is some need for some review of the Supreme Court judgment. All kinds of things are there. Therefore, it's very interesting topic where one of our very erudite judge has agreed to come and lecture to you. Even though Chengappa is no more and has not been with us for the last over 15 years, we really miss him. He was one of the gentle souls and one of the finest of lawyers and human beings. I don't think half the audience here have seen him, and had you seen him, you would have adored him like I do. Thank you very much.
Thank you, sir, for sharing such thoughts, memories, and enriching us with these memories. Om Asatoma Sadgamaya, Tamasoma Jyotirgamaya, Mrityorma Amritangamaya, which translates to say, lead me from unreal to real, from darkness to light, from death to immortality. With this prayer, we call upon the honorable members on the dais and the EC members of LAHARI Advocates Forum to come forward and light the lamp.
We now invite Sri Chandrasekhar Chanaspor, EC member, LAHARI Advocates Forum, to introduce the speaker of today's event, Honorable Justice Sri S.R. Krishna Kumar, Judge, High Court of Karnataka.
Good evening, dignitaries on the dais and off the dais. It's a great pleasure for me to introduce our speaker today, who is going to speak to us about evolution of LGBTQIA plus rights, who known for his positive and motivational attitude towards society, his dynamic range of acquaintance towards judiciary. I would like to introduce Honorable Mr. Justice S.R. Krishna Kumar, born on 7/5/1970. Justice Krishna Kumar's father, Sri S.V. Raghavachar, who was one of the most respected lawyers in the Karnataka. Honorable Mr. Justice graduated LLB at University Law College, Bangalore, enrolled as an advocate on 29/8/1992. From 1992, practiced as an advocate in the High Court of Karnataka as well as civil courts, criminal courts and tribunals. Practiced on all types of civil cases, criminal cases, writ petitions, appeals, arbitration cases, company cases, motor vehicle cases, matrimonial and consumer disputes. Appointed as additional judge of High Court of Karnataka and taken oath on 23/9/2019 and permanent judge on 1/3/2021. Thank you, sir.
We now request Honorable Justice Sri Krishna Kumar to take on the dais and enrich us with his take on evolution of LGBTQIA plus rights. Please, sir.
Honorable Justice P.S. Dinesh Kumar, esteemed brother and sister judges who are present, ladies and gentlemen, senior counsel, members of the bar, and my dear friends. India is evolving, as all of us know, as a society with diverse ideas and an inclusive structure. Our country has always been a home to a complex society with numerous and varied communities living together. Our constitution espouses fundamental principles like equality, inclusivity, and diversity. In this context, it's important for all of us to address the rights of the LGBTQIA plus community. But before we do that, we need to discuss certain concepts such as sexual orientation and gender identity, which are different from each other, and some common terms associated with these two concepts. Sexual orientation refers to a person's enduring sexual or romantic attraction to another person. Sexual orientations can include heterosexual, gay, bisexual, asexual, and other orientations. Heterosexual refers to a person whose enduring sexual or romantic attraction is to the people of the opposite sex, also known as straight. Gay refers to a person whose enduring sexual or romantic attraction is to people of the same sex. Lesbian is the preferred term for women. Bisexual refers to a person who has the potential to be sexually or romantically attracted to people belonging to the same and opposite sex. Asexual is used to describe a person who does not experience sexual attraction. Similarly, aromantic refers to a person who does not experience romantic attraction. Now coming to gender identity, which is different. Gender identity refers to one's own internal, deeply held sense of self and their gender. Everyone has a gender identity. For most people, their gender identity matches the sex they were assigned at birth. They are referred to as cisgender. Transgender is used to describe people whose gender identity does not align with the sex that they were assigned at birth. Many people have a gender identity of man or woman. For other people, their gender identity does not fit neatly into one of those two binary genders. They are referred to as non-binary. Persons who are cisgender and heterosexual are sometimes referred to as cishet. Intersex refers to someone with one or more innate sex characteristics that fall outside of traditional conceptions of male or female bodies. Finally, queer is a term used to describe people who are not cisgender and heterosexual or cishet. It is an umbrella term that can refer to a multitude of sexual orientations, health advisories, and words spoken by clergy. These paths of persecution entrenched homophobia, that is, prejudice or hatred towards gay, lesbian, bisexual, or queer from various backgrounds. They found strength in supportive medical research, outlawed books, and an atmosphere of increased democracy. The social milieu of feminism and the emerging anthropologies of difference in the Western world contributed to the recognition of sexual minorities by the 20th century. However, leaders and organizers of homosexual social movements struggled to address the very different concerns and issues of gay men, lesbians, and others identifying as gender variant or non-binary over 150 years, roughly spanning from 1870s to the present. The majority of historians concur that proof exists of homosexual behavior and same-sex relationships in every culture that has been chronicled, regardless of whether these relationships were tolerated or frowned upon. The Bible forbids homosexuality, so we know it existed in ancient Israel. It was also common in ancient Greece among men and women. There is also substantial evidence for those who identified as gender non-conforming at birth or who lived at least a portion of their lives as such. As alternatives to the Western male-female and heterosexual binaries, the LGBTQIA plus community has flourished for millennia and across cultures, from the lyrics of the same-sex desire written by Sappho in the 7th century BCE to youths raised as opposite sex in cultures ranging from Albania to Afghanistan, from the female husbands of Kenya to the Native American two-spirit. In the Indian context, many a times the LGBTQIA plus is dismissed as a contemporary phenomenon or an idea of the urban elitism. Yet, Indian mythology and history paint a very different picture. Renowned mythologist Devdutt Patnaik claims that in Sanskrit and Tamil, there are more than 50 terms for non-heterosexual genders and sexualities. Napunsaka, Kliba, Kinnara, Pedi, and Pandaka among them. The Vedas, the Itihasa, the Puranas, the Kamashastra, Natyashastra, Ayurveda, Jain Agamas, and the Buddhist Pitakas all refer to these texts. An important figure who was neither man or woman is mentioned in Vedavyasa's epic, the Mahabharata. Shikandi, one of the most well-known figures connected to the LGBTQIA community. Although Shikandi was born with female genital organs, their father, King Drupada, reared them as a son and taught them the arts of statecraft and warfare. The Pandavas' victory in the Battle of Kurukshetra was greatly aided by Shikandi's presence. Shikandi's story is not only one that appears in Indian epics, but another significant tale that acknowledges gender fluidity and queerness are those of Brihannala, where Arjuna lives as a eunuch dancer in King Virata's court. The Supreme Court has accounted for the rich history of the queer community in Indian history and mythology in its judgments in Nalsa versus Union of India, AR 2014, Supreme Court 1863. The Supreme Court said, and I quote, Lord Rama in the epic Ramayana was leaving for the forest upon being banished from the kingdom for 14 years, turns around to his followers and asks all the men and women to return to the city. Among his followers, the Hijras alone do not feel bound by this direction and decide to stay with him. Impressed with their devotion, Rama sanctions them the power to confer blessings on people on auspicious occasions like childbirth and marriage, and also at inaugural functions, which it is believed set the stage for the custom of Badhai, in which Hijras sing, dance and confer blessings. The Honorable Chief Justice of India, Dr. D.Y. Chandrachud, in the latest recent Supriya Chakravarti versus Union of India, says, and I quote, "In India, persons with a gender-queer identity who do not fit into the binary of male and female have long been known by different names, including Hijras, Kotis, Aravanis, Jogappas, Tirunambis, Nupi Manabas, and Nupi Manabis. In fact, the term transgender, as it is understood in English, or the third gender, does not always fully or accurately describe the gender identity of those who are known by some of these terms. Additionally, the social structure of the communities of transgender persons in India is unique and does not mirror Western structures. It is native to our country." Not only did LGBTQIA plus culture impact mythological texts, it also permeated the culture of our temples. The temples found at the Khajuraho heritage site in Madhya Pradesh, dating back to early medieval India, showcase powerful images of same-sex love. The sculptures found in this grand sacred complex, openly validating homosexuality, suggest that such ideas have been accepted as quite natural and pure in the subcontinent. The notion that queerness was exclusive to the urban or the elite and that sexual and gender minorities didn't exist elsewhere was firmly countered by Honorable Chief Justice Chandrachud in paragraph 93 of Supriya Supra, and I quote, "To imagine queer persons as existing only in urban and affluent spaces is to erase them even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized. Urban centers are themselves geographically and socially divided along the lines of caste, class, religion and caste, and not all those who live in cities can be termed elite merely by virtue of their residence in cities," unquote. In the contemporary context, we need to understand that gradually society has started to recognize various relationships these communities used to share with the general public. With respect to sex, negotiating Hijra identity in South India, Gayatri Reddy documents the different manifestations of kinship in the Hijra communities, including the Guru-Chela or the teacher-disciple relationship, the mother-daughter relationship, and the Jodi or bond with a husband. She describes how many Hijras enter into unions with men who are referred to as their Panthis. These unions span over many months or many decades, depending on the couple in question. In many communities, Hijras are customarily invited to auspicious events such as birth of a child to bless the family. Ruth Vanita, an academician, studied the history of queer marriage in India in her scholarly works. Her book titled Love's Right, Same-Sex Marriage in India and the West records numerous instances of queer unions and partnerships in India. The AIDS Bedbhav Virodi Andolan, that is the AIDS anti-discrimination movement, released a citizen's report on the status of homosexuality in India titled Less Than Gay in 1991. This report goes into detail as to how Indian society started to recognize that homosexual communities existed in cohorts in certain parts of the country. In Loving Women Being Lesbian in Unprivileged India, Maya Sharma gives an account of various persons, most of whom are women, in same-sex or queer relationships. This shows how there emerged queer communities in India that led to the demand for rights. In pre-colonial times, the Indian subcontinent was home to a diverse population with its own unique understanding of sexuality, companionship, morality, and love. Stories, history, myths, and cultural practices in India indicate that what we now term queerness was present in pre-colonial India. It would not be a faithful description of the times to say that queerness was accepted by the populace. Rather, society did not often view many manifestations of the queer identity as something that required acceptance to begin with, because it formed a part of ordinary day-to-day life similar to heterosexual or cisgender identities. This was true for many parts of the country at many points in time, though perhaps not everywhere and at all times. Now, this is not to suggest that society did not inflict any violence upon members of the LGBTQIA plus community in pre-colonial times. Rather, it is to highlight that current beliefs, attitudes, and practices that are hostile to the LGBTQIA community are not necessarily successors of the past. Despite legal headway, deeply entrenched societal attitudes persist in segments of the population, resulting in the continued stigma and discrimination faced by the LGBTQIA plus community. Familial rejection remains a harsh reality for some, leading to mental health challenges and social isolation, emphasizing the ongoing need for cultural transformation. The reading down of Section 377 of the IPC, while monumental, underscores the pressing need for comprehensive anti-discrimination laws addressing various facets of LGBTQIA plus rights, including workplace discrimination and protection from hate crimes. A legislative void surrounds issues such as same-sex marriage and adoption rights, necessitating urgent attention and legal rectification. The trajectory of LGBTQIA plus rights in India is not uniform across states, with some regions exhibiting resistance to embracing these rights. This reflects a need for targeted awareness campaigns and education initiatives. Regional disparities underscore the imperative of tailoring advocacy efforts to address unique challenges with specific geographical contexts within zones. Then the next question, the next aspect I would like to address this audience is with regard to queer representation in modern Indian media, or modern Indian media with reference to movies and books. The earliest representation of queer folk in Indian media has been criticized by academicians and scholars who noticed that characters were often queer-coded with no explicit representation. Anupama Arora and Nikki Sylvia, in their research about queer representation, noticed that these characters were sidekicks or comic relief and are mocked and caricatured as effeminate, or they are vilified and pathologized as scheming, predatory, or deranged. However, there were those that deviated from this norm. Deepa Mehta's movie Fire, which came out in the year 1996, created ripples with its seminal portrayal of same-sex relationships in India, invoking the ire of conservative groups across the world. The cinematic piece has been the subject of immense discussion and criticism, but it has also played an undeniable role in generating much-needed discourse about the subject of queer representation on the big screen. Vikram Seth was one of the few Indian writers who dealt with the issue of homosexuality. In some of the works, he simply referred to it while in The Golden Gate, which came out in the year 1986, he deals with it in great detail. He says, and I quote, "Workers of lungless labs, when dying, will you be proud you were midwife to implements exemplifying assaults against the heart of life? You knew their purpose, yet you made them. If you had scruples, you betrayed them. What pastoral response acquits those who made ovens for Auschwitz? Indeed, it is said that banality of evil is its greatest shock. It jokes, it punches its time clock, plays with its kids. The triviality of slaughtering millions can't impinge upon its peace or make it cringe," unquote. In the 1990s, the representation of queer folk in Bollywood was mostly negative and stereotypical. In some cases, queer characters were portrayed as villainous or morally corrupt. One of the most well-known examples of this kind of representation is the character of Lajja Shankar Pandey, played by actor Ashutosh Rana in the film Sangharsh, which came out in the year 1999. This film was heavily criticized for its reinforcement of negative stereotypes of the transgender community. Queer characters are often portrayed with much more dimensionality and even play major roles in content in OTT platforms relative to their film counterparts. Web series like Hush Hush and The Fame Game have garnered praise for their deft job in subtly weaving a character's sexuality into the narrative without making it the linchpin. Indian media has yet to question the false dichotomy between Western and Indian values, which seek to state that queer love is non-indigenous. The born this way narrative is thus a very often a convenient take, since it localizes the problem in an abstract idea of mindsets of people, instead of inspecting how discrimination against the queer community is systemic and structural. It offers no insight into the institutional challenges faced by the community. Indian law has taken several strides in recent years towards recognition of the rights of the queer community, and yet has regressive roots that can be traced back to the British Raj. Lord Macaulay introduced the provision of Section 377 IPC, which criminalized all kinds of non-procreative sexual intercourse. This despotic law was not only directed against homosexuals, but also covered all other forms of non-traditional sexual intercourse, even in the course of heterosexual union. The first collective action against these was in the report of AIDS Bedbha Virodi Andolan, AIDS anti-discrimination movement, titled Less Than Gay, in the year 1991. The report called out for repealing the said section. An independent organization brought this to the forefront by filing a petition in Delhi High Court in 2001. Nas Foundation challenged 377 on the grounds that they are violative of fundamental rights, and Delhi High Court struck it down, as all of us know. The Delhi High Court took the view that Article 15 of the Constitution prohibits discrimination on several enumerated grounds, including sex. The court preferred an expansive interpretation of sex so as to include the prohibition of discrimination on the grounds of sexual orientation, and that sex discrimination cannot be read as applying to gender simpliciter. Discrimination, as per the court's view, on the basis of sexual orientation is grounded in stereotypical judgments and generalizations about the conduct of either sex. Another facet of the Indian Constitution that the court delineated was that of inclusiveness, as the Indian Constitution reflects this value of inclusiveness deeply ingrained in the Indian society and nurtured over several generations. The court categorically said that those who are perceived by the majority as deviants or different are not to be, on that score, excluded or ostracized. In the High Court's view, where a society displays inclusiveness and understanding, LGBTQIA plus persons can be assured of a life of dignity and non-discrimination. It further opined that the Constitution does not permit any statutory criminal law to be held captive of the popular misconceptions of who the LGBTQIA plus are, as it cannot be forgotten that discrimination is the antithesis of equality, and a recognition of equality in its truest sense will foster the dignity of every individual. The Delhi High Court held, and I quote, "The absent any evidence of serious harm deems the provisions objective, both arbitrarily and unreasonable. The state interest must be legitimate and relevant for the legislation to be arbitrary, non-arbitrary, and must be proportionate towards achieving state interest. The discrimination severely affects the rights and interests of homosexuality and deeply impairs their dignity." It further opined that social morality has to succumb to the concept of constitutional morality. On the basis of these reasons, 377 was declared unconstitutional. The Delhi High Court judgment was challenged before the Apex Court in Suresh Kumar Kaushal versus Nas Foundation, 2014, 1 SCC page 1, where it was reversed, and the judgment of the Delhi High Court was set aside by the Honorable Supreme Court. Simultaneously, there was one other petition, NALSA, filed in the Supreme Court, in which the relief was sought for recognition of transgender as a gender for want of rights. The Supreme Court held in the said case that the state must recognize persons who fall outside the male-female binary as third gender persons, and that they are entitled to all constitutional guaranteed rights. It also directed the union and the state governments to grant legal recognition to the self-identified gender of transgender persons, including when they identify as male and female. The court said in NALSA, and I quote, "Hijras, eunuchs, apart from binary gender, be treated as a third gender for the purpose of safeguarding their rights under Part 3 of our Constitution and the laws made by the Parliament and the state legislature. Transgender persons' right to decide their self-identified gender is also upheld, and the center and the state governments are directed to grant legal recognition of their gender identity, such as male, female, or as third gender." To support their proposition, the Honorable Supreme Court relied upon several judgments of courts from Australia, New Zealand, and from the House of Lords, which I will not deal with in detail for the present. These judgments, in the opinion of the Honorable Apex Court, were of immense significance, as they established an important fact that various countries had given recognition to the gender identity of queer persons in cases where transsexual persons started asserting their rights after undergoing what is known as sex reassignment surgery, SRS, of their reassigned sex. One famous example is the famous tennis player Martina Navratilova's coach, Rini Richards, whose story has been filmed and came out as a movie called Second Serve, in which they show how Rini Richards, who competed in the women's US Open 1976, following a male-to-female sex reassignment surgery. In NALSA case, the Honorable Supreme Court declared, and I quote, "Hijras, eunuchs, apart from binary gender, be treated as third gender for the purpose of safeguarding the rights under Part 3. And they issued a slew of directions with regard to what the central and state governments should do to recognize and protect the rights of the LGBTQIA community. Subsequent to NALSA, a writ petition seeking to declare the right to sexuality, the right to sexual autonomy, and the right to choice of a sexual partner as a part of the rights guaranteed under Article 21 of the Constitution, and to declare Section 377 to be unconstitutional, was listed before a 3-judge bench of the Apex Court. The petitioners argued that the matter must be referred to a 5-judge bench in view of NALSA Supra. The bench also referred Suresh Kumar Kaushal which had reversed Nas foundation of Delhi High Court to a larger bench. The bench observed that the expression order of nature referred to in section 377 IPC is not a constant but is guided by social morality as opposed to constitutional values, and that a section of the population should not remain in a constant state of fear while exercising their choice. The Constitution bench, in an elaborate 500-page judgment in Navtej Singh Johar versus Union of India, 2000, page 791, held that section 377 is unconstitutional to the extent that it criminalizes consensual sexual activities by the LGBTQIA community. The bench held, and I quote, section 377 IPC in the present form being violative of the right to dignity and the right to privacy has to be tested both on the pedestal of Articles 14 and 19 of the Constitution as per the law laid down in Maneka Gandhi versus Union of India and other legal authorities. An examination of section 377 IPC on the anvil of Article 14 of the Constitution reveals that classification adopted under the said section has no reasonable nexus with its object as other penal provisions such as section 375 IPC and the POXO Act already penalize non-consensual carnal intercourse. This judgment also held that 377 has to be decriminalized as it violates the right of privacy as established in Puttaswamy 9-judge bench versus Union of India. One judgment was rendered by the Honorable Justice Deepak Mishra. Justice Indu Malhotra rendered a separate judgment, and Honorable Chief Justice Chandrachud, the present CJI, held that Article 15 prohibits discrimination based on sex, which includes within its meaning sexual orientation as well, and Section 377 indirectly discriminated between heterosexual persons and LGBTQIA community based on their sexual orientation. The Supreme Court, speaking to Justice Chandrachud, further said that the right to sexual privacy also captures the right of the LGBTQIA community to navigate public places free from state interference. The community does not face discrimination merely based on their private sexual activities. It extends to their identity, expression, and existence. The Supreme Court declared that the members of the LGBTQIA+ community are entitled to full range of constitutional rights, including the right to choose with whom to partner with, the ability to find fulfillment in sexual intimacies, the benefit of equal citizenship, and the right not to be subject to discriminatory behavior. The Supreme Court in Navtej went beyond decriminalizing sexual offences. It recognized persons in love and persons find love and companionship in persons of the same gender, protected the class against discriminatory behavior, and recognized the duty of the state to end discrimination faced by the queer community. In the latest, Supriya Chakravarti versus Union of India, which is now said to be pending in review before the Apex Court, at the instance of the queer community. Despite decriminalization of queer relationship and with the broad sweep of the decision in Navtej, the queer community is still a stigmatized invisible minority, and its members face discrimination in employment, health care, and personal rights. The ghost of Section 377 lives on despite its decriminalization, and recognition of the queer persons in Navtej Supra, which have been alluded in the recent judgment of Supriya Chakravarti. In the said judgment, which had a majority view of Justice Ravindra Bhatt, Hima Koili, and Justice Narasimha, and a minority view of Honorable Chief Justice Chandrachud and Justice Sanjay Kishan Kaul, Justice Chandrachud says, and I quote, "The impact of Section 377 on society must be viewed in terms of its effect on the social conceptions of love and companionship. enforced morality through law by shaping beliefs about queer identity. This far-reaching impact of the legal regime is one of the primary reasons for the continuing widespread revulsion against the LGBTQIA plus community. Even after homosexual acts have been decriminalized, the lack of sensitization and ensuing discrimination has pushed the members of the community into the proverbial closet. For many members of the LGBTQIA plus community, expressing their sexual orientation and gender identity is an act of defiance which requires strength and courage. The ostracism extends across the full range of social values from parenting to public office. Despite the Honorable Supreme Court recognizing that sexual orientation is a core and innate trait of an individual, members of the queer community continue to face economic, social, and political marginalization in several tangible and intangible ways. These issues were brought to the forefront when the queer community asked the Honorable Supreme Court to recognize their right to marry. Now, if we break down Supriya Chakravarti into the various aspects, the key questions that arose for consideration, this is what we will find. Question number 1, is the Supreme Court the right forum to recognize queer persons' right to marry? Honorable Chief Justice Chandrachud answered this in the affirmative. Underscoring the importance of judicial review, he indicated that Supreme Court was the appropriate forum to consider a queer person's right to marry. In April-May 23, the Union government had argued that the court's intervention would encroach on the legislative domain and breach the doctrine of separation of powers. The doctrine stipulates that the three organs, the legislature, the executive and judiciary, perform their own distinct functions. According to Justice Chandrachud, the power of judicial review is an essential element of this doctrine. Thus, the court is within its powers to consider whether the fundamental rights of queer persons were being violated. Justice Butt disagreed and held that the court, though the court may feel the wisdom of a measure or a norm that is lacking, it must be careful not to venture into the powers and functions that are constitutionally awarded to other departments and organs to discharge. Though the impact of lack of legal entitlements to queer persons are discriminatory, the court cannot fashion a parallel legal regime comprising of defined entitlements and obligations which would be required in this case. Question number 2, is there a fundamental right to marry? Unanimous decision was no, but the different judgments were rendered by all the 5 judges, except Justice Hima Kohli, who along with Justice Butt wrote one judgment. Question number 3, do queer couples have a right to enter into a civil union? In answer to this question, there was a split verdict. Justice Chandrachud in the minority held that queer couples have a right to enter into a civil union. He observed that the right to enter into a union includes the right to associate with a partner of one's choice. He stated that the ability to form intimate associations plays a vital role in fulfilling the self-development of a human being. For the full enjoyment of such relationships, it is necessary that the state should accord recognition to such relationships. He stated, this right to enter into a civil union, the chief held, is protected under Article 19, namely the freedom of speech and expression and the freedom to form associations. He referred to Nalsa case and elaborated on what was said in Nalsa case by the Honorable Supreme Court and Navtej's case. Justice S.K. Kaul agreed with Justice Chandrachud and said that the right to form a civil union is a feature of Article 19 and 21. Further, principles of equality prescribe the right to form this union is available to all, regardless of sexual orientation and gender. Leading the majority opinion on this question, Justice Butt agreed with CJI that all queer persons have the right to relationship and choice of partner, cohabit and live together as an integral part of choice. But he went on to say, ordering a social institution would require a completely different legal framework with a new universe of rights and obligations. This would require a separate regime for registration of civil union, laying down conditions of a valid union such as setting eligibility age, etc. Justice Narasimha agreed with the opinion of Justice Bhatt and Justice Hema Koili. The next question was whether the Special Marriage Act 1954 was it unconstitutional for excluding non-heterosexual couples. The unanimous decision was no. However, this is what they said. This is what Justice Chandrachud said. Referring to the root of all problems, that is section 4, Justice Chandrachud held that declaring the provision unconstitutional would diminish the purpose of progressive legislation that the Act incorporates. The SMA, he reasoned, was enacted to bolster interfaith and intercaste relationships. Therefore, declaring it null and void would take India back to the pre-independence era, where intercaste and interfaith marriages were impermissible. Such a judicial verdict would not only have the effect of taking nation back to the era when it was clothed in social inequality and religious intolerance, but also would push the courts to choose between eradicating one form of discrimination and prejudice at the cost of permitting another. In contrast to the Chief's opinion, Justice Kaul held that SMA was violative of Article 14 as it discriminates against queer persons, and he went on to elaborate. Justice Bhatt began by referring to various judgments and gave his own reasons as to why a Special Marriage Act could not be declared as unconstitutional. Question number 5, can the right to marry be read into the provisions of the Special Marriage Act? Here again, the unanimous verdict of various opinions of Honorable Chief Justice of India and the other judges was that we cannot read the right to marry into SMA. Then question number 6, which is probably more relevant, which may be gone into in detail when the review petition is being considered, is whether unmarried non-heterosexual couples adopt. CJI Chandrachud referred to Section 57 of the Juvenile Justice Act and referred to the CARA guidelines and said that the provision does not expressly impede unmarried couples from adopting a child because it uses the word spouse and not married couples. An unmarried couple may also include queer relationship. However, Justice Bhatt led the majority and held that a complete reading of Section 57(2) makes it clear that it concerns only joint adoption by married couples, and reading both married and unmarried couples into the provision is not based on any known principle of interpretation. Question number 7, can transgender persons in heterosexual relationships marry under existing law? Unanimous decision was no. And again, huge number of directions were issued by the Honorable Supreme Court. To my knowledge, the Union government has not done anything so far, which led to Justice Muralidhar in one of the seminars stating that a time limit should have been fixed. Now, when the Union government will go ahead and implement these directions, we'll have to wait and watch. Now, the right to, the other aspect of the judgment, if we can look at it from this, we can look at this from various angles. The right to marry a partner of one's choosing is not expressly provided for in our Constitution, but finds a place in international treaties, namely Article 16 of the Universal Declaration of Human Rights, UDHR, and Article 23 of the International Covenant of Civil and Political Rights. It is important to note that both these provisions are largely interpreted to include protections for non-heterosexual couples as well, with various UN human rights mechanisms urging member states to legally recognize same-sex unions. It is hence imperative for all of us to rise to the occasion. The non-recognition of the right to marry a partner of one choice also has an insidious secondary effect in that it promotes, this is very important, it promotes the institution of lavender marriages. The term lavender marriage is used to describe a marriage between a man and a woman in which at least one party is gay, undertaken as a marriage of convenience to hide the sexual orientation of one or both partners due to the social stigma attached to those identities. While these might deliver a certain layer of protection and freedom to the individuals involved, lot of queer people are forced into unhappy marriages in the fear of pitting the family name and pressure of keeping tradition happy. While the constitutions of Mexico, New Zealand, Portugal, South Africa and Sweden provide protections based on sexual orientation, India still lacks a basic law that recognizes the protection of rights of people belonging to the LGBTQIA plus community or criminalizes any harassment or discrimination against them. Besides allowing same-sex marriages, adoption and surrogacy, countries such as Bolivia, Ecuador, Fiji, Malta and the UK have gone further and enshrined the right to equality for citizens based on sexual orientation and gender identity in their constitutions. India, however, has no legislation that would recognize the rights of people from the LGBTQIA community with respect to marriage, adoption, surrogacy and health. However, it certainly cannot be said that all is lost, for we have seen several positive developments that encourage optimism for the future. Numerous Indian corporations have implemented LGBTQIA plus friendly policies such as providing equal opportunity, employment, fostering safe and supportive work environments, and creating an equitable workplace. The corporate sector's proactive stance has not only propelled workplace inclusivity but has also influenced broader societal attitudes, underscoring the catalytic role of the private sector in effecting cultural change. Post the landmark decriminalization, tireless efforts by activists and legal scholars aimed at securing comprehensive legal recognition and protection for the LGBTQIA community, advocacy has been directed towards anti-discrimination laws and the acknowledgement of same-sex relationship. A marked increase in the visibility of LGBTQIA plus individuals in media, entertainment and popular culture has been instrumental in reshaping public attitudes. Cinematic representations, television's narratives and advocacy campaigns have collectively humanized LGBTQIA characters and experiences. The burgeoning scale of pride marches, which all of us know, and related events across major Indian cities serve as a testament to the growing sense of community and solidarity. I would like to take this opportunity to shed light on the valuable work and dedicated efforts of local organization here in Bangalore, CSMR, who organize our annual Namma Pride marches, Vandede, Jiva and the Center for Law and Policy Research advocate for the rights of sexual and gender minorities, while Swabhava and Rahi provide support services to LGBTQIA plus individuals. Even our own Rotary Club has also joined hands with Solidarity Foundation, and together they work on projects that have had a positive impact on the lives of members of the local queer community. Numerous other local organizations also work in the fields of crisis support, medical and mental health support, providing safe spaces, employment support, etc. Concluding, it is essential to underscore that conventional arguments against LGBTQIA plus rights are steeped in cultural, religious or traditional perspectives, often neglecting the fundamental principles of equality and non-discrimination. A careful observation of the politico-legal landscape of progressive and developed countries reveals that India still has a long way to go in ensuring the right to equality and the right to life and personal liberty of the queer community. The very existence of queer people challenges the systemic and structural biases deeply rooted in the cis-normative, heteronormative Indian society. The lack of adequate legislation and anti-discrimination laws has prevented any progress from Navtej judgment of the Supreme Court. Within the legal frameworks and human rights discourse, the advocacy for LGBTQIA plus rights are firmly rooted in the pursuit of equitable treatment under the law, transcending considerations of sexual orientation or gender identity. Approaching these discussions necessitates sensitivity and acknowledging the diversity of perspectives shaped by individual beliefs, cultural contexts, and legal frameworks. Nevertheless, international human rights standards increasingly promote the notion that all individuals, regardless of their sexual orientation or gender identity, should receive equal treatment and protection of their rights. I deeply thank the LAHARI Law Forum for providing me this opportunity to speak on this very contemporary, happening topic, which I'm sure many of you will take more interest and read up more as what I have done while preparing this lecture. Thank you very much.
Thank you, sir, for sharing such an in-depth knowledge, reminding us that LGBTQIA plus community is not been a recent development, but has indeed been a part of our community from the age immemorable, and that it is not a sin to either belong to it or to support to it, and also to bringing out the necessity of legal framework, that is dire necessity of the legal framework that is required in the present day India. Thank you once again. Now we invite Mrs. Madhavi, EC member, LAHARI Advocates Forum, to introduce today's guest of honor, Honorable Justice Shri Dinesh Kumar, Judge, High Court of Karnataka.
Good evening, dignitaries on the dais and dignitaries of the dais. Indeed, it's my privilege to introduce Honorable Justice P.S. Dinesh Kumar. Honorable Justice was born on 25th February 1962, studied in a national high school, college at National College and BMS College, Bangalore. He was awarded National Merit Scholar Certificate in the high school. Honorable Justice started his practice in the High Court of Karnataka in the year 1990 in the chambers of Honorable Justice Shivraj V. Patil, former Judge, Supreme Court of India. He was appointed as an additional central government standing counsel in the year 1998 and has a senior standing counsel in the year 2003. Honorable Justice has served as senior panel counsel for Central Bureau of Investigation, senior standing counsel for BSNL, Union Public Service Commission, and he has worked as a mediator and a trainer in a mediation and the defamation cases against the Union Finance Minister, corruption cases, and Honorable Justice appointed as an additional judge of Karnataka High Court on 2nd January 2015 and permanent judge on 30th December 2016. Thank you, one and all.
Thank you, Mrs. Madhavi, EC member, LAHARI Advocates Forum. Now we request our guest of honor to speak a few words and enrich with us his wisdom. Please welcome Honorable Justice Shri Dinesh Kumar, Judge, High Court of Karnataka.
Very good evening to one and all. Honorable Judges, Mr. Holla, Senior Counsel, the Additional Solicitor General, Mr. Pujari, Senior Advocate, ladies and gentlemen. Today's topic, as our Senior Advocate Mr. Holla was saying, it's the hot topic of the day. The quintessence of the topic has been so elaborately and so masterly way Honorable Judge Mr. S.R. Shakumar has placed before all of you. The lecture was it dated back to Mahabharata times up till the latest judgment of the Supreme Court. The takeaway from the lecture was the last two sentences that, as per the human rights dictum, no matter what the orientation of a person is, he must be treated well and his rights must be recognized. There can be perhaps no objection of any person on this takeaway. Ladies and gentlemen, this is indeed a matter of concern in the country that persons with different orientations are there, they were there, they are there, and they are bound to be there. How they must be treated, how their rights to be recognized, and they must be given the due place of in the society, are all matters which have been more or less decided by the Supreme Court in the latest judgment, and also in the last foundation judgment of the High Court, Delhi High Court. Justice Krishna Kumar was also referring to a aftermath of the judgment that nothing much has happened, no action has been taken by the central government. But if my information is correct, the judgment of the Supreme Court is under review. So perhaps that once that it reaches a finality, the position may crystallize better and the rights of the third gender may emerge in absolute clarity. It's indeed very heartening to note that the forum has chosen a live current topic for the day and chosen one of our most erudite judges to deliver this. And thank you very much. We have overshot our time, and the subject being a new one, a detailed analysis of that was done by Justice Krishna Kumar. Thank you very much for calling me to sum up what today's lecture was. This is the takeaway that I understand. I'm sure that all of you may perhaps agree. Thank you for the patience.
Thank you, sir, for your kind words and great wisdom. Now we request Mr. Chandrasekhar, Chanasport EC member, LAHARI Advocates Forum, to present a memento to Honorable Justice Sri Dinesh Kumar as a gratitude token. Thank you, sir. We now request Mr. Rajendra Singh Chauhan, EC member, LAHARI Advocates Forum, to kindly present a memento to Honorable Justice Sri Krishna Kumar as a token of our gratitude. Thank you, sir. Every beginning has an ending, and every ending is a new beginning. With that, we request Sri Jagdish M, Secretary, LAHARI Advocates Forum, to propose the vote of thanks.
Happy evening all. As all good things come to an end in life, so is the lecture for the day. On behalf of LAHARI Advocates Forum, I take this opportunity to propose vote of thanks to those who directly and indirectly contributed on this lecture on evolution of LGBTQIA rights organized by our forum. At the outset, I thank our chief guest, Honorable Mr. P.S. Dinesh Kumar, Judge High Court of Karnataka. You are really enlightened with your knowledge and presence I thank our guest of honor, Honorable Justice, Mr. Justice S.R. Krishna Kumar, Judge High Court of Karnataka, on the insights of today's lecture. Few things I highlighted is equality, gender identity. We knew various terms and mythology, history, cultural transformation, workplace discrimination, legal rights, various judgments, pathway of constitution, etc., etc. Thank you very much, sir. That's very good. Our heartfelt thanks to Senior Counsel, Mr. Uday Holla, for bringing P.G.C. Changappa before us by sharing vividly about him. Judges of Honorable High Court of Karnataka, Judges of District Judiciary, Registrar General High Court of Karnataka, Registrars of High Court of Karnataka, Private Secretary of to Chief Justice, Private Secretary to Mr. Justice S.R. Krishna Kumar, Private Secretary to Mr. Justice P.S. Dinesh Kumar, Directors, Deputy Directors, Faculties, Trainees, Judges, and Karnataka Judicial Academy, and various other people who are present here. Well, Mr. President, dignitaries on the dais, ladies and gentlemen, an event like this cannot happen overnight. The wheels started rolling months ago. It requires planning and bird's eye for details. We have been fortunate to have backed by a team of very motivated and dedicated well-wishers of LAHARI Advocate Forum who knew their job and are result-oriented. And a special thanks to our President, Mr. S. Vivekananda, for coordinating the entire program in the last 2 months. Today's master of ceremony, Advocate Mamata, Advocate Mr. Harun Rashid, role takers, Mr. R.J. Chauhan, Mr. Chandrasekhar Chalaspur, Mr. Girish Kodgi, Mr. Sarat Chandra, Ms. Madhavi, for the unflinching support and coordination. With these warm words and kind message, we move to the end of today's lecture. We are really moved by each and everyone's actions. Thank you very much. We request each one of you to collect one booklet or knowledge bouquet about today's lecture is available outside. And for those who are online, we are going to upload this for you to download by tomorrow. Thank you very much. Thank you.
ఆప్షన్ ఎవరు పవర్ ఆఫ్ అయింది చూడ అక్కడ అక్కడ లోపల చూడయ్యా ఏమి
Thank you,